this move, in my opinion, by Coinbase is a great move, because I think what we're looking at is an interlocutory appeal if they can get it, and they can beat everyone.
In today's video, Attorney John Deaton discussed the latest with the SEC Ripple XRP lawsuit, the recent summary judgments from Ripple and the SEC, and what's next for the procedural process, likelihood of a settlement soon.
Two things to take hold in, and that is, one, there is a case at the same time as Ripple that had reply briefs in December, and just like Ripple, Judge Torres has not reached her ruling yet. And I also provided a case that took 8.5 months from the time the reply briefs were filed. We are at now 7 months, 7.5 months. So that's just another example of this takes longer than we expect. Try to be as patient as you can. It is extremely difficult. I get it, but that's where we're at with the Ripple case. Today, I'm not going to talk a lot about it, but there was a criminal case filed out of the Southern District of New York, and that involved basically someone who manipulated a smart contract on a decentralized exchange. And what I want to say about that is, that's what we want to encourage. We want to support that type of enforcement action, that type of regulation. When our regulators get it right and they pursue fraud and they pursue theft, that's what we need to support. That's where all this effort should be. So just remember, when you have a new technology like we do with blockchain and cryptocurrencies, all that is an opportunity for old age fraud, just in a new arena to be basically to take place, and we need to stamp it out. My big criticism, of course, with the SEC is that they have not spent their limited resources on the fraud, on the manipulation, on the misrepresentation, on the pump and dumps, on the meme coins that are being manipulated, and instead are focusing their attention on Section 5 cases, against good players in the business, basically, and not providing clarity. So just remember, when the regulator gets it right, we should celebrate them. When they get it wrong, we should hold them accountable. And that's what we want to do. The big news for the week has been nothing but the BlackRock ETF and the discussion. And that is a big deal, people. And the reason I say it's a big deal is because you don't get any bigger. You don't get anything more traditional finance than the largest asset manager in the world. I've heard 9 trillion, I've heard 11 trillion. We're going to call it 10 trillion. That BlackRock has 10 trillion in assets under management. Larry Fink just a few years ago gave that narrative how Bitcoin and crypto was for money laundering and things of that nature. You just fast forward a few years, and what does he tell you? He says Bitcoin is an international asset. And he also talked about crypto, and he didn't use Bitcoin and crypto interchangeably, because I believe when you read the tea leaves that he believes there's going to be more than just Bitcoin. And I don't mean just ETH by that as well. And I don't just mean XRP, that there are going to be types of cryptos. And he talked about something that we've all been talking about for years, and that is the tokenization of real world assets, real estate, stocks, traditional stocks, all of those things. And so the big winner, as far as I believe, and this is what's fascinating, and we're going to talk about how this plays out as we move forward, but who was named in all of these ETFs, these spot Bitcoin ETFs, as, let's call it, the surveillance partner or custodial exchange? Coinbase. Coinbase was listed in BlackRock's. Coinbase was listed in Kathy Wood's ARK investment, in the CBOE, 5 spot Bitcoin ETF applications. Coinbase is listed in all 5, including Fidelity. So when you have all of these major traditional Wall Streeters talking about how they're partnering and using Coinbase at the same time that Coinbase is being pursued by the SEC. I don't see how that plays out, right? Dave Weisberger, who is the CEO of, I think it's CoinShares, he's recently been saying, so I want to give credit where it's due, that we're in the negotiation phase. Remember, Tim Draper talked about with Gary Gensler on stage in 2018. They laugh at you. Then after they ignore you and laugh at you, then they get together and say, we're not going to let this happen. And then they realize they can't stop it. So what they do is they get their friends and their regulators to sue you and to litigate it. And then finally they buy you or adopt you. And David has said that we're in that negotiation phase. And at some point, I got to imagine if there's an ETF granted with a BlackRock, for example, if that happens, I think Larry Fink picks up the phone. How are you going to be using Coinbase as your partner while they're being sued? How do you report that in your quarterlies? How do you report that in your registration? All of those things, right? And so I think Dave may be onto something about this negotiation phase. And so it seems to me that Coinbase is a big winner when it comes to that. And so we'll see how that plays out. Now, speaking of Coinbase, the other big news is now we've got Coinbase had filed a letter to the judge, basically saying to the judge, we're providing the court with our intent that we're going to file a motion. It's under a rule called 12C. It is a motion for judgment on the pleadings. Now, that's something that Ripple never did. So that's something that many of the XRP holders who are now quasi experts in litigation, securities litigation, did not see. I think Ripple may have tried that had the major questions doctrine been as ripe as it is today. But basically, Coinbase said, look, they cite Gary Gensler's testimony where Gary Gensler said that crypto exchanges like Coinbase, they fall within this gap. He didn't necessarily use the word gap, but he said there's no regulatory framework between the SEC and the CFTC. And then when you couple that with the Hinman emails where the SEC senior officials talk about a regulatory gap that exists, and you take all of that and you couple it with the fact that Congress has got 15 bills that have been proposed where they're showing their intent to legislate this regulatory gap to provide that clarity to the market, Coinbase is saying, look, you don't even have jurisdiction here because you've acknowledged you don't have jurisdiction. You only have jurisdiction over securities. And in order for these to be securities, they have to be investment contracts under Howey, and they're not. And therefore, you don't even get to pursue this case, right? That is an extraordinary argument. I'm not necessarily saying it's going to win. I'm going to tell you what I think is going to happen. But it reminds me of something that hasn't gotten a lot of publicity, but there was James Katulis, a finance guy, basically was involved in the Let's Go Brandon meme coin that was meant as a joke that turned into something in NASCAR. You can look it up. But the SEC subpoenaed basically his communications with conservatives like Candace Owens, and he's moved to quash that subpoena. And XRP holders should be proud because our brief is cited throughout his motion to quash, where he's saying to the SEC, I don't have to even honor the subpoena. This is a meme coin. It's not a security. It doesn't even come close to meeting, most, if any, of the Howey factors. So they're attacking it on that level. It's a similar argument. And these are great arguments to make because it's highlighting more and more and more to the Supreme Court and to others and to Congress that you have to do something. And so basically, the SEC is pursuing basically that. And the SEC has let the judge know that the Coinbase model is basically they just find a buyer and a seller, and they match that buyer and that seller in the secondary market. And there is nothing other than an asset purchase that takes place. There's no promises made. There's no further engagement after that asset sell. Right? Same arguments you heard in the Ripple case. No post-sell obligations or duties. There's no legal interest involved. They just match the buyer and the seller. Boom. And of course, Coinbase also says, hey, they're going after our staking platform and whatnot, and arguing that proof of stake, basically the SEC is arguing that proof of stake systems basically are a investment contract, and the SEC puts all that stuff out. So, and then of course the SEC is relying on the major questions doctrine that I already discussed and citing that regulatory gap. The SEC's response to that is that they're like, okay, file your motion, but they're letting the judge know we're going to move to strike the major questions doctrine, the abuse of discretion defense, the equitable estoppel defense, and certain other affirmative defenses that the SEC pled. And of course, the SEC highlights the registration agreement. They say to the SEC, and they're saying to the judge, hey, the SEC is making a big deal about the fact that we approved their registration statement. Well, judge, their registration statement, the very one that we approved, talks about how a risk to the business is, in fact, if a regulator like the SEC states and argues that they're selling unregistered securities. And of course, when you go to Coinbase's quarterly results and they talk about risks to the platform, they talk about how the SEC could claim that certain tokens are securities. They talk about how Satoshi Nakamoto's identity, if becomes known, could threaten their business or threaten at least the price of Bitcoin. If the 1 million Bitcoin Satoshi coins are moved somehow, that's a risk. But one of the major risks are these could be called securities. And so the SEC is saying, basically, Coinbase, your argument falls on its face because you've acknowledged this from the beginning. And the point of all this is that these are boilerplate kind of comments. The SEC says, right, we are approving your IPO and your registration statement because it's in the public's interest, even though they know what the business model is. Let's all be honest, they know it. But they're going to keep disclaimers in there, right? That this isn't basically a blessing of your underlying business model. Just like when Bill Hinman or anybody gets up and gives a speech, Gary Gensler, this really can't hold me to what I'm going to say. There's these legalese disclaimers that go both ways. And I don't think either one of those are going to win the day. Ultimately, this move, in my opinion, by Coinbase is a great move, because I think what we're looking at is an interlocutory appeal if they can get it, and they can beat everyone to the appellate court, maybe even to the, if they can get to the Second Circuit and point to all this recent Supreme Court law. And if they lose there, maybe even, ask for cert, all before trying to litigate it. I'm not saying that's going to happen, but I think that is an angle that they're trying to get, to basically that would postpone even the underlying litigation in the case. And so that's basically where we're at with Coinbase and the SEC.